Good afternoon, everyone, and thank you for attending today's webinar on Proposition 64 presented by Ruthann Ziegler and Kate Cook. We hope you enjoyed the presentation and join us for the next part of the series on December 1st. A schedule of our full Proposition 64 webinar series is available on the last slide of today's presentation. A couple housekeeping items. First, all of your telephone lines are muted. If you would like to ask a question, you have Q&A at the top of your screen. Please type your question in this box. Ruthann and Kate will answer all questions until the end of the webinar. We have folks registered today, so if your question isn't answered, Ruthann or Kate will follow up with you after the webinar via email or phone. We are also offering CLE credit for this webinar. If you check the box on your registration form to receive credit, that will be emailed to you. We will also email all slides to the attendees early next week. Now, speakers, Ruthann Ziegler and Kate Cook. Ruthann has more than 30 years' experience in public law, representing municipalities and special districts. She serves as chair of the California Act Practice Group. Ruthann represents in all matters affecting local governance and decision-making. She advises clients on issues such as rate setting, public contracts and bidding, land use, the Subdivision Map Act, and environmental issues. Ruthann is a member of the Ad Hoc Medical Marijuana Committee of the City Attorney's Department of California Cities. Kate is a member of the Municipal and Special District Law and California Public Records Act practice groups. She serves as City Attorney for the City of Plymouth and Attorney for the City of Rancho Cordova. She has excellent experience in issues related to Public Records Act, the Brown Act, election law, and marijuana regulations. So that's all for administrative matters. Please welcome Kate and Ruthann.
This is Ruthann Ziegler, and you'll be hearing voice initially and then Kate's voice. We do have someone who's commented to us about the audio being interrupted every time someone signs on with a ding. We understand that, and we're really good attorneys, but we have no idea from an IT perspective how to keep on live so you can hear us and not have the dinging. So our apologies for the dinging, and it just may be one of the unfortunate side effects of having good attendance and a live webinar. So going on to the overview, which is slides that you have in front of you now, let me give a few preliminary remarks. We fully realize whether you're an attorney or a non-attorney, but that the whole issue of Prop 64 continues to be controversial. There are some people that view talking about one extreme versus the other, some who view marijuana as a gateway drug, some who view strong supporters of Prop 64, believe that it recognizes current situations and avoids unfair incarcerations of those who may be involved in marijuana. Our role, both Kate's role and mine, as well as that of Myers-Brave, is one of neutrality. We do not have an opinion pro or con. It is our role as attorneys to work with our clients constructively to carry out the direction consistent with the law. I personally have done everything from working with clients to impose as far-reaching bans as possible, since that was the direction from my client, to getting successful sales tax measures on the ballot, to working with another municipal client who wanted to not only allow marijuana cultivation, but wanted to implement large-scale warehouses for cultivation. So that's a bit of perspective as to our role, both here with Kate and me, both today and our firm overall. The areas that we're going to touch on are those bullets you see in front of you: the personal use, personal cultivation. By virtue of the fact that we have an hour, that we will not be going in depth into all these matters. That's why we're having not one webinar, but a series of webinars. If for any of you, you have suggestions for additional webinar topics that you do not see covered in our list, we are delighted to receive your suggestions and get additional input. Going on to some of the substance of the Prop 64, and please assume when I talk about marijuana, I am talking about the marijuana, unless I specify to the contrary, I'm talking about marijuana as allowed by Prop 64, whether we refer to it as non-medical marijuana or recreational marijuana. I'm talking about, let's say, Prop 64 marijuana. Prop 64 allows an individual to possess a certain quantity. Prop 64 actually says 28.5 grams. I have no clue why it's measured in grams, but 28.5 grams roughly equals 1 ounce. And an individual under Prop 64 is now allowed to possess, process, transport, purchase, obtain, or give away up to 1 ounce of marijuana. Please notice that one can give it away. You cannot sell it under the category of personal use. That is a commercial operation and will be covered later. This applies to individuals who are aged 21 years and above. The individual, in addition, at their residence, can possess, plant, cultivate, harvest, dry, or process up to 6 living marijuana plants, as well as the marijuana from that. And if that amount, the product from those 6 living plants is more than 1 ounce, they are still within the permissible range of Prop 64, I believe, as long as it stays at their residence. They are allowed to smoke or ingest the marijuana. They're also allowed to, for a person 21 years and up, possess, transport, purchase, obtain, use, manufacture, or give away marijuana accessories. Again, notice the reference to give away, not sell. What is and is not a marijuana accessory is also defined in Prop 64. Personal cultivation, as I said, one is allowed to have up to 6 living plants. That is allowed at your at a residence, and I want to make clear that I mean a residence as opposed to a structure. 6 per residence, not 6 per person or 6 per resident. Okay, a residence is defined by Prop 64 as a home, apartment unit, a mobile home unit, or similar dwelling unit. The personal cultivation of up to 6 plants is allowed indoors within a locked space, or in addition to indoors, it can also be in a locked, enclosed shed, structure, etc. However, cultivation in one's backyard in an unenclosed area is a different category, as it were. For that personal cultivation, either within the residence or within the locked space, a city or county can regulate that use or cultivation. However, it cannot ban it. In contrast, if the marijuana is in an unlocked space or in someone's backyard, South 40, etc., even if it's only 6 living plants or even 1 living plant planted outdoors, let's say in a vegetable garden, unenclosed space, a city or county, if it so chooses, can ban completely that outdoor cultivation. In addition, there are locational restrictions. Locational restrictions for the personal use are from reference 1,000 feet from schools. The 1,000 feet from schools, it is from any school, daycare center, or youth center. Both daycare center and youth center have definitions. Prop 64 references those and has specific definitions of those that are cross-referenced in the Health and Safety Code. Please notice that the 1,000 feet prohibition with school, daycare center, youth center applies when children are present at such location. So the 1,000-foot restriction would not necessarily apply at 2 a.m. when presumably children are not present. A little kind of back and forth here is that the 1,000 feet restriction does not apply if one is using it at a private residence unless, and this is, as it were, an exception to the exception, unless the odor from the residence is detectable at the school, daycare center, or youth center when children are present. So to put that in a little bit more concrete terms, if there is a residence next to a school, the person can, if they so desire, smoke in their backyard, even though they're within 1,000 feet of the school, as long as the odor is not detectable at the school, daycare center, or youth center, while children are present. I suspect that this may be an area of dispute and subjectivity as to people who find an odor to be present and people who do not find an odor to be present. I've made a reference there to public places. In addition, one cannot smoke, use, etc., the marijuana in a public place. Public place is not defined in Prop 64. Public places are obviously streets, sidewalks, public buildings, etc., but also it would be considered to be someone's front yard. Front yard, even though, again, not defined in Prop 64, is generally considered under California law to be a public area, public space. And again, to reinforce one of my other points, no sales allowed under the personal use category. I've been referencing the 6 plants, the 1 ounce. In addition, in terms of the 1 ounce that's allowed is of not what's called not concentrated marijuana or not concentrated marijuana product. For what's called concentrated cannabis, and for reasons of which I'm not quite clear, Prop 64 refers to marijuana generally, but in this particular area it refers to concentrated cannabis. If it's concentrated cannabis, the amount which is allowed for personal possession is 8 grams. And for those of you who aren't perfect, such as myself, for converting grams to ounces, 8 grams is approximately 0.282 ounces. Okay, for going to the next slide, for commercial operations, again, getting out of the category of personal use. For commercial operations, the Prop 64 has adopted, as it says, 19 categories of what are considered commercial operations. 13 of those relate to cultivation. The other 6 are the ones that you see listed there. These categories are quite specific, ranging from, and they have various subcategories. So, for example, I'm going to take an example of Type 5. Type 5 is cultivation outdoor large. Then there is 5A, cultivation indoor large. 5B, cultivation mixed light large. Within Prop 64, and to just give you an example as to kind of how some of the hyper-technicality of some of these cultivation categories, again, just taking Type 5 as an example. Type 5 outdoor is outdoor cultivation using no artificial lighting greater than 1 acre, inclusive of total canopy size on one premises. That's 5 outdoor. Then there's 5A indoor, which is using exclusively artificial lighting, not greater than 22,000 square feet. In case you're curious, 22,000 square feet is roughly half an acre. And then there is Type 5B of mixed light, which means using a combination of natural and supplemental artificial light, greater than 22,000 square feet, etc. So for persons or entities interested in those 13 categories of commercial cultivation, just please know that they are portions of Prop 64 are hyper-technical as to how those clarify those. The state will be issuing licenses. Kate will go into that in some more detail. But to give you an idea, there are a number of standards and considerations spelled out in Prop 64 about the bases on which licenses issued by the state can or cannot be granted, and bases for consideration. And for example, Prop 64 identify, and you will find these provisions. Prop 64 added a number of provisions to different statutes. Some of them are added into the Health and Safety Code. Some of them, like these about licenses, are added to the Business and Professions Code beginning around Section 26,000. But for example, under state licensing factors, just a few of the factors that the state can consider in whether to grant any of these categories of licenses is whether it would, a license would result in an unreasonable restraint on competition, whether it would perpetuate an illegal market for marijuana or marijuana products, whether it would encourage underage use, whether there would be an excessive concentration of licenses in an area, and those are only some of the multiple factors that the state is to consider in deciding whether or not to grant licenses. In addition, licenses are not to be granted if someone will be selling or otherwise providing marijuana products at less than cost for the purpose of undercutting or injuring competitors. There is to be no what's referred to as discrimination between different sections, communities, or cities or portions thereof in terms of where businesses are to be located. The other point I would make this, and then I'm going to turn this section over to Kate to give some more give a little bit more detail, is that there is also priority established by the state in terms of granting licenses. One area of priority that sticks around for the first few years of Prop 64 is priority to California residents, whether that is an individual or a business that has been operating in California for a certain period of time. In addition, priority is to be granted to any applicant who has been operating in compliance with the Compassionate Use Act on or before September 1st, 2016. Later on, we're going to go a little bit more into some of the local regulations or bans which are allowed under this area. At this point, I'm going to turn the presentation over to Kate to give some more information about commercial operations.
Some of the other commercial operation categories that Prop 64 covers include the micro business category, kind of a interesting term. When you look up that section of the Business and Professions Code, it describes that commercial category as a business where they're cultivating less than 10,000 square feet. They're also distributing. They're like a smaller distributor and a retailer. So that's kind of a license category that allows for almost seed to sale with one license holder. And this is one way that Prop 64 differs, I would say, from the medical regulations that were passed. There's not the same restrictions on license holders in the AUMA from holding licenses in other categories. The only exception to that would be the testing license. That's one of the categories of commercial licenses. And if one holds a testing license under Prop 64, similar to the medical regs, you may not hold another license for any business that does marijuana. That applies to individuals as well as someone who might have an ownership interest in another business that's licensed. And the idea of that is it's a pretty common sense concept, I think. They just want to make sure that the testing arm of this regulation, that it's completely separate and not connected to the sales, to the manufacturing, to the distributors, so that individuals and the state agencies can trust that the outcome of all those tests that are done are being done in an objective way. There's retail licenses as well, and under the AUMA, retail licenses include deliveries. So I'm going to continue to talk more about commercial operations. As Ruth Ann mentioned, the state permits are going to be issued. They have until January 1st of 2018 to begin issuing those. The AUMA requires that the state start issuing them by that date. It's possible that they could issue the permit sooner, at perhaps the end of 2017. The Bureau of Medical cannabis regulation that was established under the medical marijuana regs is now being renamed, and that entity is called the Bureau of Marijuana Control. And that agency is under the Department of Consumer Affairs, and it has the primary, authority and responsibility for implementing and enforcing the AUMA, as well as developing many of the further regs that are going to be coming out in this next year. Like I said, the timing is January 2018 that everyone's expecting those licenses to come online. It is illegal until then for anyone to operate a commercial marijuana business without a state license. So this gives, in terms of cities and counties, local jurisdictions have some time to update their own regulations to state whether they want to allow commercial recreational marijuana businesses or ban them. Another area with permits that is different in the AUMA, that's different than with the medical regulations, applies to the local permits. If folks are aware, under the medical regulations, it was a dual license. It's a dual licensing authority. So under the medical marijuana regs, a commercial business may not get a medical marijuana license without providing proof to the state that they have permission from the local agency. Prop 64 is different in this way. Prop 64 specifically says that they do not have to provide that documentation to the state. It simply puts the responsibility on the state licensing agency to not give out licenses if it would violate a local regulation. So if a local city or county has a regulation that prohibits commercial medical marijuana businesses, it will be really important for the city or county to communicate with the state licensing authorities and let them know that they have those regulations. There's some other regulations called for in the licensing portion of the statute. If someone has a commercial license to have a recreational marijuana business, they may not have a license, they cannot also have alcohol or tobacco sales happening at that location. There, as Ruth Ann mentioned, there's going to be some priorities. Local residency, California residency must be established. I believe it's by January 1st of 2015 for the first year or so of the regulations. After that, local residents will be given priority. The application requirements are going to be quite extensive, and they may be expanded. Right now, businesses are going to be required to provide details on their operations, fingerprints, information on security measures, all kinds of things, and those might be expanded upon. Local water control boards are given authority to come up with their own permits for some of these cultivation businesses in terms of discharge that will be coming from them. So I think in the next year we'll see a lot more regs rolled out from different agencies at the state. So there's a lot to keep on top of, and we'll try to do that in our future webinars and throughout the year, but it's going to keep evolving. So under this licensing scheme of Proposition 64, there's three main departments of the state that are going to be handling it. The first is the Department of Consumer Affairs. That's where the Bureau of Marijuana Control will be housed. It's also the department that will handle licenses for the retail sales, which includes delivery, transportation, distribution, and storage of marijuana. The Department of Public Health will handle the manufacturing licenses and the testing licenses. Manufacturing basically refers to individuals or entities who are doing the extraction, doing the edibles, creating marijuana products from marijuana. And then the Department of Food and Agriculture will oversee the cultivation, licensing, and enforcement, as well as regulations for that. And one more thing on the licensing structure under Prop 64. There's also a lot, Ruth Ann mentioned a few of these. You know, there's some unfair competition rules inside the regs, and there's also some anti-monopoly regulations inside the statute. It includes provisions that, you know, some of those large-scale businesses and cultivators, those licenses won't come on for about 5 years. The whole goal of Prop 64 was to really give advantage to those small and medium-sized businesses in the first few years, kind of to prevent those big business monopolies from taking over in California. And on November 3rd or December 1st, we're going to do a more in-depth webinar on commercial regulations. So moving on to workplace issues. We're also going to have a more in-depth webinar on this topic in December as well. But for workplace issues, the main thing I think to remember with Prop 64 is that it doesn't really change much. Private and public employers still have every right that they have under the law now to have drug-free, you know, alcohol and drug-free policies, and presumably marijuana is going to be covered in those policies. In business and it's in the Health and Safety Code 11362.45F. Prop 64 says that the rights and obligations of public and private employers to maintain a drug and alcohol-free workplace or require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growth of marijuana in the workplace, or affect the ability of employers to have policies prohibiting the use of marijuana by employees and prospective employees, or prevent employers from complying with federal law. So basically that section says that that's not affected by Prop 64. Employers may still have their rules and regulations and handbooks that tell employees, nope, you cannot smoke marijuana at work, you cannot show up stoned, you cannot be, you know, making marijuana trades on our property. And also it makes sure to point out that employers don't have to allow, you know, growth and transport and all of that. So the federal rules in terms of how they apply to employment and employment matters are completely going to be the same, because marijuana, if everyone recalls, is still an illegal Category 1 substance under federal law. And if everyone also remembers, or perhaps not, but under, you know, when it comes to the ADA, there is case law that says that, you know, there is no right under the medical marijuana laws. No one has the right to medical marijuana in the workplace. So Prop 64 doesn't change that. Employers still have a lot of power when it comes to this area. And Prop 64 also, in a general sense, gives private property owners rights to prohibit, you know, use or possession or anything related to marijuana on their property. So it goes beyond, you know, employers, and landlords could be covered in that category too. So transportation and delivery. Moving on to the next slide. We did mention that under the commercial license categories, these are some of those categories. Delivery is covered under the retail license, and basically delivery of recreational marijuana, cities and counties, if they would like to, can still prohibit it. They can prohibit deliveries within their own jurisdiction. But Prop 64 does say that local jurisdictions may not prohibit delivery companies from coming through, from using your roads to get from one place to another. And also Prop 64 is a little different than the Medical Marijuana Regulation and Safety Act, in that if you are conducting a delivery business, you don't have to originate from a dispensary. It doesn't have to be tied to a brick and mortar business. That is the rule under the medical marijuana regs, and that's not the rule under the AUMA. You simply have to have a retailer license to do deliveries. Moving on to taxation. This is a popular category when it comes to marijuana. Under Prop 64, the state, starting on January 1st of 2018, may impose a 15% excise tax on all marijuana sales. That's recreational and medical. There's also going to be a cultivation tax on leaves and on flowers that differs depending on each of those. But there's going to be a lot of taxes being, paid by purchasers and distributors and cultivators of marijuana. One prohibition that the AUMA puts out there is that the sales and use tax may not be charged to qualified patients who are purchasing medical marijuana. But the excise tax is still going to apply to all marijuana. Local taxes, local entities may still, under Prop 64, impose local taxes on marijuana. Typically, the process to do this is to put a ballot measure out to your voters and determine what they want. A lot of cities and counties have been holding workshops and public meetings to try to get input from not only their residents, but the industry itself, because the industry does have concerns that with the state excise tax and the cultivation tax, and perhaps add sales tax onto that for recreational, and then maybe a local business tax or a local excise tax or even a local sales tax, that all of this adds up and it may become 25 or 30% tax by the time, they're done and doing their books. So a lot of local entities are seeking input, not just from residents, but from folks in the industry to find out, what they need to do if they want to be competitive in this field.
And this is Ruth Ann Ziegler again. I'm going to present the next slide or two. I will say as a side point that I've noticed that, and this, I don't know if this is a good thing or a bad thing, we so far have no questions posted. So either people are very focused on their lunch, or Kate and I are being crystal clear, or somewhere in between. So doing a little compare and contrast on various provisions concerning recreational versus the medical marijuana. Part of it is the extent of local control, which I will go into a little bit more in the next slide. But for example, for medical marijuana, if a city or county so wanted to, under medical marijuana, all indoor cultivation could be prohibited. But in contrast, for the recreational Prop 64 marijuana, one has to allow at least, the cultivation of the 6 plants, which I've mentioned before. There's also a difference. I'm not going to reference taxation except to maybe say that I've seen some numbers that there were, 50 or 60 marijuana-related matters on the November ballot among cities and counties. I know that some jurisdictions, whether cities or counties, impose their own sales tax in addition to what was authorized by Prop 64. I'm even aware of some communities that is a very proactive step, authorize or place on the ballot a sales tax on commercial operations, even though at that time such jurisdictions are not authorizing commercial operations. Perhaps just looking forward to should the state or a future voter initiative require commercial operations to be allowed. There's also a difference in recreational versus medical marijuana as to quantity. Again, my apologies if this sounds a little bit redundant, is the personal use is allowed for up to 6 plants. Under the original Prop 218, the Compassionate Use Act relating to medical marijuana, that series of statutes initially and still does refer to 6 mature plants, up to 6 mature or 12 immature plants. However, for those of you who have been following this, I'm sure you're already aware that there was a court case that said that the state legislature couldn't regulate the number of plants which someone could use or needed for medical use. That instead was set up by their physician in their recommendation, and therefore you have an interesting situation where for recreational you can have up to 6 plants, personal that you grow at home, medical, and let's say a city, for example, has to allow that indoor personal cultivation of up to 6 plants. In contrast, for medical, a city, if it so desired, could ban all indoor cultivation of medical, and yet can't say that more than 6 mature or 12 immature plants is not allowed for medical marijuana. If this sounds a bit confusing, I think in part it is. There's also different terminology between the two sets of statutes now. Again, for those of you familiar with medical marijuana, the various statutes, the term qualified patient is very familiar. A qualified patient or a person with an ID card who has a recommendation from their physician. And again, it is technically an oral or written recommendation as referenced in Prop 218, SB 420, and not a prescription, because a prescription is something that's governed by federal law, FDA, and of course, referencing Kate's prior comment, under the Controlled Substances Act, which is the federal law, no form of marijuana is recognized as permissible. It is still considered to be a type 1 controlled substance. But there's certainly different terminologies between Prop 64 and medical marijuana. Again, emphasizing the point I have here, one talks about a qualified patient, which actually could be a minor, versus someone who is 21 years and up as to the non-medical marijuana. Future legislation, we always know that's going to happen. I'm aware, because of my role with the League of California Cities, it was, I think it's still named Medical Marijuana Task Force. I understand there will be a bylaws change to merely name the group Marijuana Working Group or Task Force, and whereas originally we were, or at least until this point, an ad hoc committee, I understand that group will be, if the bylaw amendment goes through, be made a permanent standing committee within the League. But it's my understanding that the League, and I'm sure other groups as well, will be looking at some legislation in 2017. I think one area of possible change is that, as Kate mentioned, there's an interesting dichotomy for local licensing, that if there is a commercial operation, it must show that it is allowed by a local jurisdiction. In contrast, if someone is applying for a Prop 64 type commercial operation, they can do so regardless of whether or not they are allowed to by the local jurisdiction. And I think there may be some interest from the League, quite possibly other groups, in terms of equalizing that and making it such that for when it's a commercial permit, whether it's medical or non-medical, there has to be showing from the applicant for the state license that they have some degree of authorization from the local city or county in which they are located. I'm sure there will be other trade groups that will be pursuing some cleanup, clarification, perhaps amplification under Prop 64. The other area, even though it's not referenced here, but I think another area that there'll be a lot of focus especially from the law enforcement community, is establishing a standard for what is or is not driving under the influence. We all know that driving under the influence for alcohol is the blood alcohol level 0.08 and above. There is no equivalent for marijuana. Marijuana is very different in terms of how it's tested, that it can stay in, for example, residual amounts in one's hair strands for a very long period. It's my understanding the approach that law enforcement takes is that you can still be arrested and or convicted for impaired driving, regardless of what marijuana level you may or may not test at. But I know that in Colorado, which legalized recreational marijuana prior to California, there's been a lot of emphasis and interest in study and developing some sort of marijuana equivalent testing level to the .08 for blood alcohol. One of the challenges to doing that is that any scientific testing, if there are federal grants involved, need federal authorization for such testing, since again, under the Federal Controlled Substances Act, marijuana is a type 1 controlled substance. Going on to the next slide, going a little bit into local regulations, what is and is not allowed. Very simply, that under Prop 64, a city or county can ban all commercial operations, period. A city or county can ban all outdoor growth, cultivation, etc., whether for personal or commercial use, period. The two areas that, and I want to quickly clarify what I just said about outdoor use. The two areas, and also reinforcing something that Kate said before, local jurisdiction cannot ban transport or regulate transport through its boundaries of marijuana. So if you're City B and City A allows commercial operations, and someone in City A needs to drive through City B, your city, to get to City C for delivery, you cannot ban that. You could only regulate it in the same way you could regulate any other transport, such as truck traffic or speed limits or things like that. But you could not have any regulations unique to marijuana transport through your jurisdiction. In contrast, local jurisdictions, cities or counties, can ban delivery within their jurisdiction. That's clear under Prop 64. I think it can be a bit challenging in terms of enforcement, but I just want to give a heads up that that is allowed. In addition, going back to the cultivation issue, a city or county can only regulate that personal cultivation of up to 6 plants, whether up to those 6 plants are inside your residence or inside an enclosed structure in your backyard. And I am aware that some cities, and some of you may already be on the phone listening, have already enacted bans to the extent permissible. I think some cities and counties are looking at it, and I think also there are some cities and counties that see this as a tremendous opportunity in terms of revenue production. I know that here within the city of Sacramento, there are several options being evaluated in terms of commercial operations, where they would be located, how the revenue would be used, etc. So it is my feeling, and it kind of underscores my comment I said at the beginning, it's a matter of what, if you look at it from a city or county perspective, what the governing board may want, want or not want in terms of preferences, to ban to the extent possible, to regulate only that which can be regulated, or to allow limited commercial operation, broader-based commercial operation as a service to the community and or a source of revenue. And as you can see, our next slide is a colorful hodgepodge of rectangles, which is where we answer various questions and answers.
So I'm going to attempt to answer a few questions that I see popping up about taxes. There's quite a few in there. I'm going to try to cover the main. There's quite a lot of questions now coming in, so if we don't get to all of them, please bear with us. We will be in touch with you to answer them.
Let me also point out that Kate and another colleague, Denise Bazzano, are the ones who will be presenting on commercial operations, and they are somewhat the go-to people within our firm as to that area.
So as to taxes, I'll just repeat some of the basics, and then I'll answer some of the really great questions we've gotten. The state tax that's going to start up January 1st, 2018 is going to be a state excise tax, 15% on gross receipts, and the section that addresses this is the Revenue and Taxation Code, Section 34012. It clarifies that it's 34011 is the excise tax. The cultivation and the other taxes are under 34012. So effective January 18th, 2018, January 1st, 2018, it's going to be a 15% excise tax. And one of the questions was, is that embedded when you then are calculating sales and use tax? And the answer to that is yes. The provision makes it clear that that is the case. And that excise tax on the sales is also, that's in addition to the standard sales and use tax that gets charged on sales. Another question that seemed to be coming up was had to do with the outdoor cultivation and whether or not local jurisdictions may ban. As Ruth Ann repeated again, yes, when it comes to Prop 64, local jurisdictions may still ban any and all outdoor cultivation if they wish to, and case law still gives cities, and your land use authority still gives cities and counties the right to ban outdoor medical growth. The city of Live Oak is the case that you're going to want to look to for that. Someone asked for that case site.
I'm going to answer a question or two that's popping up here. There's a question about, can an employer prohibit marijuana use off-duty? I believe the answer is no, but you have to consider it's like. It's no different than alcohol. If you come in the next day hungover from alcohol or under the effects of marijuana, that's going to be problematic. One other area that might be worthwhile checking into, and we will make sure and have an answer to this when we have our webinar about employment. I know there are very tight federal regulations related to trucking, both commercial trucking and operation of certain large commercial vehicles. And those may have additional provisions about what you're allowed to do off-duty in terms of the rollover effect in terms of on-duty. There's another question here about the deliveries. It is correct that we can prohibit deliveries into but not transport through. That is referenced very specifically in Prop 64. I'm asking my staff who's here to make note of the person who asked that question, and I will email you later, assuming we have the email address, where those specific sites are. I don't know, for those of you who've had the pleasure or challenge of reading Prop 64, it is over 60 pages long, and while I have read the entirety of it more than once, I do not have it memorized.
So someone is asking for the name again of the policy that can help employers to continue to have a drug-free workplace. And usually that's an employer will have just, a drug and alcohol-free policy within their employee handbook or their employee regulations. Under Health and Safety Code 11362.45, Section F, I read that earlier, and it makes it clear that the rights, of a public or private employer to maintain a drug and alcohol-free workplace is still in place after Prop 64. So you are, still allowed to have your rules as far as employees go about possession intoxication, all of that stuff as it relates to marijuana for current employees and prospective employees.
Yes. Okay. We're, in case you want to know about the pause, we're glancing at the questions and making sure that we're not being redundant here.
There's a great question here. When do the personal use provisions go into effect?
Now.
Now, November 9th, 12:01 a.m., November 9th, those went into effect.
Right. So people can, if they so desire, start growing those 6 plants in their backyard.
Within their home, if they...
Within their home. Sorry, not in backyard. Backyard, no, you need your tough shed from the hardware store.
One question I've gotten on that personal use topic regarding, those being in place now. Remember, there is a prohibition in Prop 64 on the smoking or, ingesting smoking marijuana in public places. And Ruth Ann mentioned before that, the term public place, it's kind of broad. It's not defined in Prop 64, and so what we need to do is look to case law. And case law talks about a public place can certainly be private property. A public place can be a parking lot that's a private property. Public place can be a private property shopping mall. A public place really is anywhere that is readily accessible to the public without a challenge or without a barrier they have to cross. So if someone has a front yard, a front porch that's easy to walk up to, that is very likely going to be considered a public place, and you won't be allowed to smoke marijuana in that public place. However, if someone has their front yard fenced in to try to prevent people from coming into it, then they may likely be able to smoke marijuana there. So that term public places is, I think it's going to get bounced around a lot in the next couple months as people kind of test out these laws, and perhaps we'll get some case decisions on that. Another question that has come up for me from a client is, if we do allow a commercial business, say a retail shop, in our jurisdiction, do we have to allow them to let people use on site? And the answer to that is no, you don't. But if you would like to, if your local jurisdiction wants to become the niche for the retail store and vape bar, you certainly can. There's provisions in the Business and Professions Code section, I believe it's 26200, that say that if a city or county wants to allow a business to have smoking or vaping or ingesting on site, they can, but there's a couple rules about it. It has to be an area that's only accessible to individuals who are 21 and older, and it also has to be completely not visible from a public place. So you wouldn't be able to, walk by on the sidewalk and see that people are smoking marijuana within that business.
One of the questions that I see here that we didn't touch on, the question is whether a residential property owner can prohibit a tenant from growing marijuana, and what can a property owner do. In Prop 64, yes, there is a specific provision that allows a landlord to prohibit a tenant from growing, possessing, etc. And if you like, we can pull out, as I said, I don't have all 60-plus pages of it memorized, but we can pull out that section and send you an email about it. Another question here, whether there's any indication from the state that they'll be prosecuting commercial recreational activity that occurs prior to licensing being issued. I personally have heard nothing. Have you heard anything, Kate?
Well, I haven't heard anything as to whether they're going to be, going after folks, but Prop 64 does allow for, civil enforcement, and I think the, penalties up to 3 times whatever the license amount becomes, and every day that you operate without a commercial license would become a violation, and it also allows the state to confiscate any product. So I think that they put some regs in there that are scary enough to businesses who have a lot of money invested in this, especially in their product, that folks hopefully won't be operating without a license, without a state license, because the penalties are pretty harsh, and I'm guessing it would very likely prevent them from getting a license when they start issuing licenses. So I don't, they're pretty busy coming up with their regs right now. I don't know that they're going to be out there prosecuting folks. Prop 64 does tone down a lot of the punishments for marijuana violations, but they do have hefty, fines and enforcement when it comes to civil penalties.
There are two related questions here. One of them is any idea of what, I think the question's phrased is any idea about what would be reasonable regulations for indoor grows, and then a related question is which cities have already tackled this issue, and the person admitting what we as city attorneys all know continues to say, any ordinances I can copy extensively from. Yes, I actually have both, not just I, but my firm has several clients that enacted bans and regulations to the fullest extent allowed by Prop 64 prior to Prop 64 passing. The effective date of those ordinances was 12:01 a.m. November 9th, and should Prop 64 pass. For those of you who would be interested, since more than one person may be interested in that, for those of you who may be interested in ordinances that our firm has prepared and clients have adopted both as to indoor regulations and bans to the fullest extent allowed by Prop 64, please email us, whether you email me, Kate, or whomever, and we will get it to you. Maybe not today, but within the before Thanksgiving, we'll make that commitment to you.
So there's some other questions just on that personal use and possession part of Prop 64 that went into effect November 9th. So one person asked, can people start sharing that 1 ounce or less? And the answer is yes. They can. You can't sell it to someone, but you may share it. And also, there's another question that says if recreational sales are currently prohibited, how can you acquire product to use, grow, et cetera? And I think that's sort of a real-world issue of, I don't know that if someone were to be stopped with, if a law enforcement agency came across your personal marijuana stash, that there's any way for them to know how you received that. You are allowed under Prop 64 to share marijuana with someone, so it is totally legal now for someone to give marijuana to anyone who's 21 and older. If you have more than that 28.5 grams, it does require that it be locked up and secure.
There's a question here about an inconsistency between the Prop 64 and the Prop 64 that allows 8 grams for concentrates but penalizes possessions of more than 4 grams under other provisions of the Health and Safety Code. I would think that the Prop 64 trumps existing law, but if you feel that inconsistency is still there, I would encourage you to contact the league, the lobbyist, et cetera, or if you want to, email me and I'll follow up as a member of the committee, because the goal, one goal at least from the league, is to have cleanup legislation that avoids any inconsistencies. Two more tax questions. Recommendation not be submitted. Kate and I are making sure we've answered all the questions on the screen. So that's why you hear a little quiet discussion between the two of us.
It says, does the provision eliminating sales and use tax on medical marijuana purchased by qualified patients include local as well as state sales and use tax? My understanding is that, yes, starting January 1, 2015, the AUMA prohibits the imposition of state and local sales taxes on medical marijuana being qualified patients. So many of our clients have worked with them to develop an excise tax or a business tax that taxes the retailer, not the purchase itself, and those, in our opinion, are still going to be in place. So that may be something for local jurisdictions to consider going back to the voters if they need to amend, if they only have a local sales tax. But again, the local sales tax still apply to the recreational marijuana in addition to that 15% excise. One more question, and then we're going to wrap it up.
Do you want to pick one? There's a question here about assuming the property owner can also prohibit tenants from growing medical marijuana. I think that's an interesting question. I actually have a colleague who has a number of rental units who says that he gets confronted by tenants who claim that they have a right to grow it for personal medical use. I think that is unlikely, and actually if you want to email me separately about that, I will follow up with you about some cases on that. For those of you still on the line, we appreciate your patience with all the beeping as people get off the line, and we're going to see if we can address that some way or another in future webinars. We really appreciate your listening here, and you will see for the next screen that I just clicked on, not that I'm trying to show pictures of Kate or me, but I want to highlight the future webinars that we'll be having, and we hope that many of you and or your colleagues tune into those, and thank you very much.
Thanks so much.